If you've just been arrested for your first DUI in Contra Costa County or anywhere in California, you're probably overwhelmed with questions about what happens next. A first DUI is the starting point that sets the minimum and maximum sentence for the crime. However, the county you're in can make a big difference. No county is particularly DUI friendly, but in some places getting the minimum sentence is more difficult. An experienced Contra Costa County lawyer knows whether a DUI interlock is required and whether the statutory minimum sentence is a guarantee or something that has to be earned. Whether a DUI interlock is required and whether the statutory minimum sentence is a guarantee or something that has to be earned. Under California Vehicle Code Section 23152, a first-time DUI for driving under the influence of alcohol or drugs is almost always charged as a misdemeanor. But that doesn't mean it's a slap on the wrist. Even without prior offenses or injuries, the consequences can range from a manageable inconvenience to a life-altering disruption. Today, we're breaking down the best-case and worst-case sentencing scenarios for a first-time DUI under current 2026 California law. This is based on Vehicle Code Sections 23152 and 23536 DMV rules and how courts actually handle these cases in practice. Keep in mind that every case is unique, and outcomes depend heavily on the facts, your attorney's skill, and the county where you're charged. Statutory penalties for a first-time DUI with no injury. California law sets clear minimum and maximum penalties for a first offense under Vehicle Code Section 23536. Jail time ranges from 96 hours, with at least 48 hours continuous unless it conflicts with work, up to 6 months in county jail. Fines start at a base of $390 up to $1,000, but with mandatory penalty assessments, the total often reaches $1,500 to $2,500 or more, depending on the county. Courts almost always impose 3 to 5 years of informal summary probation. You'll face a mandatory alcohol or drug education program, usually 3 months or 9 months if your BAC was 0.20% or higher. The DMV imposes an immediate 4-month administrative per se suspension if you failed or refused a chemical test. Upon conviction, this often results in a total 6-month suspension period. The statewide Ignition Interlock Device Program, extended through 2033, frequently requires installation for 4 to 6 months to obtain a restricted or full license reinstatement. You pay for installation, monitoring, and removal, typically around $100 to $150 per month. Additional common requirements include proof of SR22 high-risk insurance for 3 years and, in some counties, a victim impact panel. Best case scenario: minimal disruption, no jail. With a strong defense and an experienced DUI attorney, many first-time offenders avoid the worst outcomes. Here's what the best case typically looks like. No jail time. The judge grants probation instead of incarceration. This is extremely common for clean first offenses with no aggravating factors, and jail alternatives are often provided. In some cases, the prosecutor may agree to a wet reckless plea under Vehicle Code Section 23103.5. This is still a misdemeanor but carries lighter penalties, including a shorter license suspension, no mandatory IID in some situations, and a less damaging record. You can often get restricted driving rights quickly by installing an IID, allowing you to drive to work, school, and the DUI program. You'll complete a 3-month DUI school if your BAC was under 0.20%. Total out-of-pocket costs are roughly $2,000 to $3,500, covering fines, fees, school, IID rental, and insurance increases, spread over time. Probation is usually 3 years of informal probation with standard conditions like no drinking and driving and obeying all laws. For a cooperative defendant with a good lawyer, the realistic outcome is pleading guilty or no contest, serving no jail, driving with an IID, completing school, and moving on after 3 to 5 years of probation. Your record will show a DUI or wet reckless, but you can keep your job and mobility. Worst case scenario: maximum penalties and long-term fallout. If the evidence is strong, such as a high BAC, failed field sobriety tests, refusal of a chemical test, or other aggravating factors, the judge can impose the maximum penalties. This could mean the full 6 months in county jail, though it's rare for a true first offense. You could face the maximum $1,000 base fine plus all assessments, totaling $2,500 or more. DUI school could extend to 9 months. You might receive a full 6-month or longer license suspension with no early restricted privileges if the court views you as a safety risk. The IID could be required for the maximum period, up to 6 months or longer in some counties. Probation might stretch to 5 years with stricter conditions, possibly including supervised probation. Additional consequences could include a victim impact panel, community service, or alcohol monitoring. Aggravating factors that push a case toward the worst outcome include a BAC of 0.15% or higher, refusal of a breath or blood test, any accident even without injury, presence of drugs, a child under 14 in the vehicle, or showing a poor attitude during the stop. In worst-case scenarios, you also face collateral damage like skyrocketing insurance rates that can double or triple for 3+ years, possible job loss especially if you drive for work or hold a commercial license, and a permanent criminal record that affects background checks. In worst-case scenarios, you also face collateral damage like skyrocketing insurance rates that can double or triple for 3+ years, possible job loss especially if you drive for work, and a permanent criminal record that affects background checks. Several things decide whether your case ends up closer to the best or worst scenario. The strength of the evidence, including dash cam video, blood alcohol results, and the officer's observations. Your BAT level and whether you agreed to take the chemical test. The specific county and judge. Sentencing practices vary widely. Busy courts may follow standard sentencing, while smaller courts may view each case more independently. Hiring an attorney early. A skilled DUI lawyer can challenge the stop, the test results, or negotiate a better plea. Your criminal and driving history. A truly clean first offense helps enormously, but a prior wet reckless will hurt you. In Contra Costa County, it is often difficult to get a better deal simply because you are a doctor or other professional whose license may be affected by a DUI. Likewise, causing a serious injury can turn a first DUI into a felony. Even conduct that could have caused serious injury, such as close calls, is viewed as a strong negative factor when seeking a plea deal with minimal jail time. Bottom line, don't assume the worst, but prepare for reality. A first-time DUI in California is serious, but it is not automatically a career ender or a guaranteed jail sentence for most people. The best-case scenario of probation, no jail, and restricted driving with an IID is far more common than the worst case of full jail time and maximum penalties. The difference almost always comes down to how quickly you act and who represents you. If you have your first DUI in California, especially in Contra Costa County, call criminal defense attorney Daniel Horowitz at 925-283-1863. Daniel has extensive experience with DUIs and knows the Contra Costa County legal networks, the unspoken rules, and the likely outcomes. Call 925-283-1863.